what I want to hear from you is maybe why I should even give him, why I should follow that when I've got 1, 2, 3, 4, 5, 6 prior assaultive crimes on his record before this one, and then while he's in the jail on this one, he's committing another assault. So I am really wrestling with whether to. I've yet, up to this moment in time, heard of a reason why I shouldn't go top end of the guidelines when he's got all these prior assaults. So you want to give me another reason why I should go with county cap for him?
Not on the record, Your Honor. No.
So you've got 2 choices, and I'll give you time to talk with your attorney. Your 2 choices are these: to accept the sentence as I've given you, the 23 months to 5 years with the jail credit, or to withdraw your plea, in which case...
What you just watched, that's the moment the legal system finally ran out of patience. But you haven't seen the decades of violence that led to this explosive ultimatum, or the letter that almost changed everything. This is the sentencing of Mr. Zeno. On paper, it's a case of attempted strangulation, but in reality, it's a 20-year cycle of assault that hasn't stopped, not even in a jail cell. Why does Zeno claim he has no memory of his past crimes, while official records show a clear path of destruction across multiple states? And how does he plead for mercy while committing new assaults behind bars? Today, the judge decides if he's finally earned a permanent seat in state prison. If you want to see exactly how courtroom psychology catches the tells that most people miss, hit that subscribe button for more deep dives into real justice. Let's go back to day 1 in the courtroom.
So, Mr. Vogler, let's call People v. Zeno. That's file 25-93384FH. Counsel, please state your appearances, beginning with People.
Jeremiah Buffalo on behalf of the people.
Mr. Vogler here for Mr. Zeno. Mr. Vogler, have you had a chance to review the pre-sentence report recommendations with your clients?
I have.
And this is for an attempt strangulation. It's a 5-year statutory maximum. Advisory guidelines at 7 to 23. Any additions, corrections, or scoring challenges from the defense?
No scoring challenges. A couple of things on the, I guess, the pre-sentence report, Your Honor. Start with the page 5 at the bottom under the it's listing as prior offenses there.
Okay.
And if we, the bottom one, if we flip it over,
This is offense 5 of 22.
yeah, 5 of 22. My client indicates he has no memory of that, and I would note that the failed appearance date on 5/4/2010. If we look at the next entry, we see him basically appearing in the very same court 6 months later. So I don't know what that case is, but I would have assumed that they would have dealt with it in the case that came after.
Yeah, that's true. You would expect that might have happened. Agent Lesky, do you know where those where that information populated from?
Yes, Your Honor. I contacted both courts. I have the court information from the case that had the majority of this court. The one from 2010 might have been just the one I discussed with.
Because both of them were the 14th District Court in Calcasieu, Louisiana.
Calcasieu.
Calcasieu?
Yes.
It looks like I did talk with that court in person, just talked with them.
Yeah. Did they give you any information about what happened after he failed to appear for the arraignment in May of 2010? Because then looks like just less than a year later, he was in the same court taking a plea and getting sentenced to 30 days jail. So it would be unusual for that court to not address the prior failure to appear.
Your Honor, if I may, I can give you the documentation that I was sent. It was actually sent by the court.
Okay. And then yeah, I don't know what happened with the case. That there are this is documentation from that court. This says in Lake Charles, Louisiana.
Yeah, that's tax sheet, right?
Okay. And it says he failed to appear for arraignment on May 4th, 2010. There was some testimony under oath. It's determined that, it was determined that defendant was not notified. And then it says that on motion of the prosecuting attorney, the matter was passed without date. Okay, so given that, maybe what we ought to do is just leave the disposition unknown, because we don't know what happened there. But can you strike under the narrative the failure to appear for the arraignment? Because part of that was also they determined that he had not been notified. So I wouldn't want that to be docked against him. So can we just delete the narrative portion under that? Offense 5 of 22.
Yes, Your Honor.
Thank you. Mr. Vogler, does that take care of that concern?
It should, yes.
Any other additions?
Entry number 11 of 22. My client kind of, he disputes that and recognize, and I'm talking about the narrative there. That's a situation, my client says that the victim in that case broke into his house while he and his wife were at work, and that the battery he was accused of and which he was convicted of actually occurred outside the residence. He never went into the residence. That's his side of that story.
Right, but he's not necessarily entitled to his side of the story in there. It's just what was the case that he was convicted of?
Simple battery, yeah. Well, I mean, because you get a home invasion charge down to a simple battery. So I'm just saying maybe that home invasion never happened.
Well, I think it's fair to include the victims, with the. I mean, I think that's an accurate description of what happened, what was charged in the case, and the final charges are there. So I'm going to leave that.
We would ask the court to update the credit. I think you already have to 146.
No objection to the jail credit change from 132 to 146 because we adjourned due to a storm.
No, Your Honor.
Last year was ice storm. This year was blizzard. Who knows what next year will?
It depends on where you work.
Any other changes from the defense?
Yeah, there is one under substance abuse treatment. It's on page 16. In the middle of the page. It shows him having went to intensive outpatient at Gateway.
Okay.
And it showed the start date of 1/1/2004. And it says he completed that. If he did so, he did it in one day. He says he was 3 months in that program.
Okay,
So,
my guess is that if he didn't know the exact dates, then maybe the program was just prompting the agent to put in a date, and she was just grabbing a random date. Would that be correct?
Yes, Your Honor, we just use one when we only know the year.
Okay, does the computer system you have allow you to just put a year?
No, but I'm sorry, that's not, Your Honor, but I did note it in the narrative that was a 90-day program.
okay.
All right, I think that's less than ideal, I'll grant you. But I'd rather that, because then it flags that, of course, the 1/1 isn't a precise date. Whereas if we made it 1/1 to 4/1 or something, or 3, then it would seem like it's precise when it wouldn't be. So I'd rather the least of errors would be to leave it as the 1-1, which flags that there's something there, and then the narrative sort of corrects that. All right, anything else?
That's it.
Okay, any additions, corrections, or scoring challenges from the people?
No, Your Honor.
All right, Mr. Vogler, go ahead with anything you want to say in your clients.
Your Honor, since Mr. Zeno has been incarcerated, he has attended all, nearly all. I think he missed a couple of AA meetings and a couple of Bible studies, but that had to do with his other incident in the jail. And that's the reason. Otherwise, he has done those that programming that they have in the jail. We would ask the court to sentence him pursuant to the sentence agreement. We somewhat anticipated that there would be a probation element to that, which.
Well, I'll tell you, I'm not considering that. What I want to hear from you is maybe why I should even give him, why I should follow that when I've got 1, 2, 3, 4, 5, 6 prior assaultive crimes on his record before this one. And then while he's in the jail on this one, he's committing another assault. So I am really wrestling with whether to send him to prison.
Well, I think that if you were to give him a 12-month jail sentence with probation, then any violation, certainly prison would be the next stop. I think an anger management with a AA and substance abuse component would assist him. This was another case where he was drinking. He has told me that he is sworn that he's done with that stuff now, and at least in his behavior in the jail with regard to attending that programming shows a certain amount of resolve in that direction. So that's, I guess, the argument I can make there.
All right, thank you, Mr. Vogler. Mr. Zeno, you don't have to say anything today, but you're welcome to. Anything you want to tell him?
Well, I mean, I learned from my mistakes. Well, been learning from a long time ago. Just that I started back drinking and everything that I'm not going to do anymore. And I think it's just time to go back to work.
So I've got assaults on your record from 2004, 2012,
Yeah, I understand.
2019. Hang on, let me finish. 2019, 2020, 2021, and on this one in 2025. So I guess I'm looking for what time window in there that you learned something. Seems to me you haven't stopped committing assaults.
As far as leaving away from the city where I'm from and coming to a new city to change, so I end up drinking again.
Yeah, well, that's the thing. When you move, you bring yourself with you.
Yeah.
So a change of scenery doesn't change the person.
Yeah.
You got to do work on you.
Yeah, I know.
Your Honor, I would just point out, I meant to do this originally, but the first 2 cases on his record are, he was 17 years old there. Here we maybe consider a juvenile case, but
Well, or back then it would have been an adult case.
if you would have, yeah.
Yeah, we didn't raise the age here until what, 5 years ago. All right, Mr. Virgo, any recommendations from you?
Your Honor, we recommend that the court sentence Mr. Zeno to the jail cap as reflected in the plea. We would note that there, without getting into it, there were compelling reasons for the plea in the instant case, and there are compelling reasons as to why the issue that happened in the jail didn't change our position on that, Your Honor.
All right, well, I guess I'm not asking you to get into stuff you might not want to get into, but I've yet, up to this moment in time, heard of a reason why I shouldn't go top end of the guidelines when he's got all these prior assaults. So you want to give me another reason why I should go with county cap for him?
Not on the record, Your Honor, no.
Well, Mr. Zeno's first assault was over 20 years ago in Louisiana in 2004, another one in 2012, another one in 2019, a domestic abuse, battery, and child endangerment in 2020. And then in 2021, a robbery that was part of a domestic assault. He moves up here. He commits an assault by strangulation, pleads to an attempt. And the night he's arrested, it says they were even unable to complete the booking process due to his argumentative and disruptive behavior. While he's in the jail, he commits another assault. And his description of the offense to the agent is all just excuses. He doesn't take any responsibility. I hear no reason why he shouldn't be at top of the guidelines sentence. So on this charge of an attempt strangulation that, lowers what those guidelines are, and lowers the statutory maximum, it would be my intended sentence to order Mr. Zeno to pay $68 in state cost, $130 in a crime victims assessment, $350 in court costs, and that I would commit him to the Michigan Department of Corrections for not less than 23 months, nor more than 5 years, with credit for 146 days previously served. The reason why I believe top end is a proportionate sentence is this history of engaging in the same type of behavior over a period of decades, and his lack of responsibility and accountability in his behavior upon arrest and after incarceration. So Mr. Zeno, that is not following the sentence agreement. So you've got two choices, and I'll give you time to talk with your attorney either now, or if you want to adjourn it and come back in May where we can decide then, I'll give you that opportunity as well. Your two choices are these: to accept the sentence as I've given you for the 23 months to 5 years with the jail credit, or to withdraw your plea, in which case we would set it for trial on all the charges. And then if you're acquitted, you're acquitted. If you're convicted, then that sentence may be the same, it may be less, it may be greater. So you can discuss those options with your attorney. Mr. Vogler, do you want to do that now? Or do you want to put it over?
I'll start it right now.
Okay.
Yeah.
So we'll give you time to talk to Mr. Vogler in the jury room and see what you like we've just got that, and then Mr. Green, which is the Attorney General, zooming in at 11. So what we'll do is we'll go off the record. All right, so we're back on the record, and we're calling People v. Zeno 25-93384FH. We did see counsel in chambers who advised that Mr. Zeno had written a letter to the court that he wanted reviewed prior to a sentence. That did not get forwarded to me, or we didn't receive it. I'm not sure what the situation is. So Mr. Zeno retrieved it with the assistance of the Sheriff's Department from his jail cell, and I have had an opportunity to review that, Mr. Zeno. Thank you. And it does not change my intended sentence that I announced. Mr. Vogler, do you know, does Mr. Zeno want this letter attached to the PSI or just or not?
You want that attached to the PSI, that letter?
I mean, yeah, attached to it, it'd be attached to.
Okay. All right. So I'll make sure I give it to Agent Lesky for inclusion with the PSI materials. And Mr. Vogler, have you had a chance to review with Mr. Zeno his options, and do you know what he wishes to do?
Well, you can correct me if I'm wrong, but I thought he indicated that he would accept the court sentence.
Okay, so Mr. Zeno, I've given you an opportunity to withdraw the plea. Do you wish to withdraw your plea or no?
No, just.
Okay, so the sentence that I announced will be the sentence of the court. And you may file an application to appeal to the Court of Appeals if you wish to challenge your conviction or my sentence or both. If you want a lawyer appointed to you, I would do so, but you'd have to ask me within 6 months. We're going to hand you a piece of paper about those appeal rights. Ask you to initial one copy for us so that we have a record we gave it to you. And the other is for you to fill out if you wish to take an appeal, okay? Good luck to you, sir.
The judge made the final call. Zeno is headed to state prison for at least 23 months. But here's the real question. Was this sentence actually fair? The law demands prison for a repeat offender, but Zeno pleaded for one last chance at rehab. Comment below, team prison or team second chance? Did the judge get it right? If this case got you thinking, hit like and share this with a friend.